Have you ever hired a builder who seemed great at first, but then the excuses started? Missed deadlines, shoddy workmanship, disappearing for days, or simply refusing to fix their mistakes. If you're feeling fobbed off by a builder, you're definitely not alone, and today, I'm going to walk you through the exact steps you can take in the UK to protect yourself, assert your rights, and get the outcome you deserve. Whether you're dealing with a half-finished extension, a bathroom that's leaking already, or a builder who's suddenly stopped answering your calls, this video will give you a clear roadmap. So grab a cuppa, hit that like button, and let's get into it. Step 1. Understanding your rights. Before you take any action, it's crucial to understand what your rights actually are. In the UK, most building work carried out for a homeowner is covered by the Consumer Rights Act 2015. This means your builder must carry out their work with reasonable care and skill. That's the legal phrase, and it's important. If the work is substandard, unfinished, or not what was agreed, the builder is legally required to put things right. They must do so within a reasonable time and at no extra cost to you. Now, if you have a written contract, brilliant. That's your strongest piece of evidence. But even if you don't panic. Text messages, emails, quotes, invoices, bank transfers, and even WhatsApp messages can all form part of a legally binding agreement. So the first step is simply this: know that you're not powerless. UK law is very clear: builders must do the job properly. Step 2. Gather your evidence. Next, you need to gather evidence. This is the foundation of everything that follows. If you ever need to escalate the issue, the strength of your evidence can make or break your case. Here's what to collect. Photos and videos of the work, especially close-ups of defects. Before and after shots if you have them. Copies of your contract, quote, or written agreement. Screenshots of messages where the builder made promises or gave excuses. Receipts and invoices. A timeline of what happened and when. Any expert reports if you've already had another professional look at the work. Don't underestimate how powerful a well-organized evidence folder can be. If you ever need to go to court, or even just threaten to, having everything documented puts you in a much stronger position. And here's a tip: if the builder is still on site, take photos discreetly. You don't need to announce it. You're documenting your own property, that's perfectly fine. Step 3. Communicate clearly and formally. Once you've gathered your evidence, the next step is to communicate clearly with your builder. And I don't mean another casual text message. I mean a formal written notice. This is where many people go wrong. They keep things informal for too long, hoping the builder will come good. But once you're being fobbed off, you need to switch gears. Your message should include 1. A clear description of the problem. 2. What you want them to do. 3. A reasonable deadline. 4. A statement that you'll escalate the matter if they don't comply. Here's an example of wording you can use. Under the Consumer Rights Act 2015, the work carried out must be completed with reasonable care and skill. I am giving you the opportunity to put this right. Please confirm in writing within 7 days that you will return to complete the work and rectify the issues. If I do not hear from you, I will consider alternative action, which may include hiring another contractor and seeking recovery of costs. Send this by email and text. If you want to be extra thorough, send it by recorded delivery too. Once you've sent this, give them the time you stated. Don't chase every day. Let the deadline speak for itself. Step 4. Get an independent assessment. If the builder ignores you or refuses to fix the issues, the next step is to get an independent assessment. This is incredibly valuable because it gives you a professional opinion on what's wrong, how serious it is, and how much it will cost to put right. You can ask another builder, a surveyor, or a specialist tradesperson. Ideally, choose someone who's a member of a recognized trade body, like the Federation of Master Builders, NICEAC for electrical work, or Gas Safe for gas work. Ask them for a written report. A breakdown of the faults. A quote for remedial work. Confirmation of whether the original work meets UK building standards. This report becomes a key piece of evidence. It shows that you're not just being picky. The work is genuinely defective. Step 5. Check whether your builder is part of a trade body. Before escalating things further, check whether your builder is part of a trade body or scheme. Many of these organizations offer dispute resolution services. For example, Federation of Master Builders, FMB. Trustmark. NYSEIC. Gas Safe Register. NAPIT. Which? Trusted Traders. If your builder is registered, you may be able to raise a complaint through the scheme. Some even offer inspections or mediation. Now, not all builders are members, and that's fine. But if they are, use it. These organizations don't want their members giving them a bad reputation. Step 6. Consider alternative dispute resolution, ADR. If the builder still isn't cooperating, the next step is something called alternative dispute resolution, or ADR. This includes mediation and arbitration. Mediation is where a neutral third party helps you and the builder reach an agreement. Arbitration is more formal. The arbitrator makes a decision that both sides must follow. ADR is often quicker and cheaper than going to court. Some trade bodies require you to try ADR before taking legal action. However, if the builder refuses to engage, don't worry, you can still move forward. Step 7. Withholding payment. Now, a big question people ask is, can I withhold payment? In the UK, you can withhold payment for work that hasn't been completed properly, but you must be careful. If you have a contract that sets out payment stages, you should follow that. If the builder hasn't met the stage requirements, you can legitimately refuse to pay until they do. However, don't withhold more than is reasonable. If the dispute ends up in court, the judge will look at whether your actions were fair. And whatever you do, don't pay the final balance until you're satisfied with the work. Once the money is gone, your leverage is gone too. Step 8. Hiring someone else to fix the work. If the builder refuses to fix the issues, you're allowed to hire someone else to put things right, and then claim the cost back from the original builder. But there's a process to follow. 1. Give the original builder a final chance in writing. 2. Get at least 2 quotes for the remedial work. 3. Choose a reasonable quote, not the most expensive. 4. Keep all receipts and reports. 5. Inform the original builder of the cost and your intention to recover it. This is called a claim for damages. You're not punishing the builder, you're simply recovering the cost of fixing their mistakes. Step 9. Making a formal complaint. If your builder is part of a trade body, follow their complaints process. If not, you can still make a complaint to Citizens Advice. Trading Standards. Your local council's building control department, if the work breaches regulations. Trading standards won't resolve the dispute for you, but they may investigate the builder if they're acting unfairly or illegally. Step 10. Taking legal action. If all else fails, you can take legal action. In the UK, most disputes with builders go through the small claims court if the amount is under £10,000 in England and Wales. For larger claims, you may need to use the fast-track or multi-track system. You can represent yourself, many people do, or you can hire a solicitor. But before you start a claim, you must send a letter before action. This letter should include a summary of the dispute, the amount you're claiming, the evidence you have, a deadline for the builder to respond, a statement that you'll start court proceedings if they don't. Most builders don't want to end up in court. A well-written letter before action often prompts a settlement. Step 11. What not to do. Before we wrap up, here are a few things you should never do. Don't threaten violence or get aggressive. Don't post defamatory comments online. Don't block the builder from collecting their tools. Don't hire someone else without giving the original builder a chance to fix things. Don't pay in cash without receipts. Don't let the situation drag on for months hoping it will magically resolve. Staying calm, organized, and professional will always get you further. So there you have it, a clear, step-by-step guide to dealing with a builder who's fobbing you off. Remember, you have rights, you have options, and you don't have to accept poor workmanship. If you found this video helpful, hit like, subscribe, and drop a comment below telling me what issue you're dealing with. I read every single one. And if you want more videos on home improvement, legal rights, and avoiding cowboy builders, make sure you're subscribed. Thanks for watching, and good luck getting your project back on track.